Further hearing in the appeal Vedanta Resources PLC and another against Lungowe and others.
Yes.
Good morning, my lady. May I move, if I may, to the first item on my roadmap, which is the question of the motivation of the claimants. For your note, we deal with this between paragraphs 23 and 31 of our printed case at MS 273 and following. A recurring theme of the appellant, certainly their written case, permeating every aspect of it, is that it is said that the claim against Vedanta is brought for an improper collateral purpose. They say the claim is motivated by little more than a desire to use its domicile as a means of entrapping KCM. It's a type of forum shopping, they say, that must not be permitted. May I summarise our response to that by giving emphasis to 6 particular points. Firstly, we submit that their arguments are largely legally irrelevant. That's because, properly analysed, the question of motive is irrelevant as a matter of law to most of the rules under consideration in this appeal. For reasons that I'll develop when I turn to EU law, we submit it has no possible relevance to Vedanta's appeal. The mandatory allocation of jurisdiction under Article 4 is exclusively addressed to domicile of the defendant without regard to any characteristics of the claimant. As to the domestic law rules governing service out on KCM, all that's left now in this appeal are the questions as to whether there's a real issue against Vedanta and whether England is the appropriate and Wales is the appropriate forum. My lady, my lords, the question of motive has no relevance at all to the former question of real issue. That was a point made by Lord Collins on the Privy Council in Ultimo. For your note, it's paragraph 76 to 79 of Ultimo, Authorities 1, Tab 6, MS 3096. And we don't understand that it said that that was wrongly decided. And therefore, despite the prominence afforded to attacks on the plaintiff's motivation, its relevance on analysis is solely limited to the question as to whether or not England is the appropriate forum, exemplified by a case in which service out is refused because a judge on the facts finds that the claim against the domiciled a defendant is a device, and the judge concludes that it would be wrong to allow the tail to wag the dog. That's reason one. Reason two is, in any event, there's no requirement in either EU or domestic law for a party seeking to pursue a claim to have to particularise, let alone evidence, his or her motivation for so doing. This applies not simply to service out jurisdictions, but to litigation more generally. It must follow, we submit, that where a party contends that a court should refuse to entertain because it is motivated by bad faith or is otherwise an abuse, it's that party who's making the assertion that must bear the burden, at least evidential burden, of making out bad faith, improper purpose, or abuse. Thirdly, we say that you cannot establish an improper motive in this case simply because the claimants wish to sue a parent company domiciled in England in respect of injuries that were sustained overseas. There's nothing appropriate at all per se in doing so. That was a point made, if it needs authority for the proposition, it's a point made by Lord Gough in the Connolly case. Can I quickly show my lady and my lords that? You'll find it in Authorities, Volume 1 at tab 9. The report starts at MS 3195. If I could ask the court to turn up first, please, page 3205 in the speech of Lord Gough, just to show you firstly the nature of the claim that was brought in Connolly, the allegation that was made. So just below letter D, Lord Gough said this: in 1993, the plaintiff obtained legal aid to bring proceedings in England. It was alleged that RTZ had devised the subsidiary's policy on health, safety and the environment, or alternatively had advised RUL as to the contents of that policy. It was further alleged that an employee or employees of the parent, referred to as their supervisors, implemented the policy, supervised health, safety and environmental protection at the mine. So not dissimilar allegations to that are pursued here. And then if I could ask the court please to turn to page 3214, MS 3214. And just below letter A, his lordship said this: I wish to interpolate at this stage, there's no question of the plaintiff in this case having founded jurisdiction against the defendants on what may be described as an extravagant basis. In a case where the plaintiff has done so, for example, by serving proceedings on an individual defendant on a brief visit to the country, the court may not be prepared to assist him by refusing a stay to enable him to keep the benefit of the advantage to him in this country. His lordship then looks at the Scottish position, and then just a couple of lines below C. Here, however, the plaintiff has founded jurisdiction as of right by serving the two defendants in this country, both of them being English companies registered here. No doubt their domicile in this country, coupled with the availability of financial assistance here, has encouraged him to select them as defendants. But I cannot see that of itself exposes the plaintiff to criticism. If he was going to sue these defendants, this was an appropriate jurisdiction in which to serve proceedings on them. My fourth point is this: there was no cogent or compelling evidence, or indeed any evidence of illegitimate motivation before the first instance court. The highest it was put was by way of assertion and inference based on the appellant's description of the merits of the case that it faced, it being said that the case against it was so palpably weak that the court must be compelled to conclude that it could only be properly analysed as a device. We say with respect that's an argument that is either OTOs or misplaced. OTOs because if they are right that the claim has no merit, then it simply fails the real issue test. Service out will be refused, and the substantive claim against the parent company will be struck out or summary judgment entered. It's misplaced because if in fact the claim survives the real issue test, then it is impossible, we submit, to see how pursuing it could ever be deemed an abuse or said to be being brought for an improper motive. The position is in fact a fortiori here, because it is now accepted before this court, it wasn't below, but it's accepted before this court that if a real issue exists between the claimants and Vedanta, then it is reasonable for the court to try it. A point made in the Red October case, in the judgment delivered by my Lord Briggs and Lady Gloucester, was that one separates out, or one should separate out, real issue and reasonable to try. And here it is accepted that if there is a real issue, it's reasonable to try. Well, in those circumstances, it's impossible, we say, to see how faith can be established on the basis of merits. Fifthly, even though not required to do so, the claimants in fact provided evidence for why they were proceeding against Vedanta. It included evidence from the claimants themselves. It included evidence on the difficulties of retaining access to justice in Zambia in this particular case. And it concerned evidence from the claimant solicitors about the concerns as to the financial stability of the second defendant, KCM. For your note, that's a position that's summarised in Mr. Day's fifth witness statement. That's Core Volume 5, Tab 47, paragraphs 119 to 126, MS 1509 and following. And you will see it includes a statement, for example, made to the Zambian Parliament on two separate occasions in the year before issue in this case, from both the Minister of Mines and the Zambian Vice President, expressing their concerns about the precarious financial position that KCM found itself, including the risk of insolvency and liquidation. And indeed, although not contained in the evidence of the claimants, that evidence was objectively corroborated by the findings of the English High Court in a series of cases granting and upholding freezing injunctions against KCM. Now, we summarise a few of those key findings in an annex to our printed case. Could I just flag up the three that are relevant to finance for now? You'll find that is the Annex 1, and if the court would be so kind to go to page 3, MS 368 in Core Volume 1. court would be just so kind as to read paragraphs 2A to C, which set out some key quotations from the 3A to C, I'm so sorry, key citations from Mr. Justice Eder, A to C, about the financial position of KCM, and also 6G and H. Sixthly, the judge considered all of the arguments and reached an evaluative conclusion on the evidence that this was not an improper device concocted for an improper purpose. Could I just take you to some of the relevant passages in the judgment, please? So we're in core volume 2, tab 2, I beg your pardon, tab 4. And if I could start, please, at paragraph 75 at MS 444.
Sorry, could I have that number again?
Yes, paragraph 75, my lady, at MS 444.
Thank you.
Now, this is in the context of the EU arguments, but you'll see later his lordship adopts it generally to the case. And between paragraph 75 to 81, his lordship sets out why he does not consider that this case amounts to an abuse or is being brought for a collateral purpose. One can see that he adopts that analysis more generally from paragraph 63 at page 442. He deals with the financial position in a bit more detail between paragraphs 21 to 24 at MS 433. And reiterates his conclusion again at paragraph 163, MS 460. We say with respect that this is precisely the type of evaluative decision-making that should not be interfered with by an appellate court unless it is plainly wrong. And we say with respect that the judge was not wrong, he was plainly right. Might I turn to the appeal under EU law? We address this in detail between paragraphs 39 and 68 of our printed case, from MS 280 onwards. Our case could not be more simple. We're proceeding against Vedanta in the court of the country in which it is domiciled under the terms of Article 4, which applies irrespective of the domicile of the claimants, of the number of them that are pursuing claims, the merits of the claims, or the underlying reason for bringing them. This is the forum mandated by Article 4, and we submit that should be the beginning and the end of it. Can I just make 5 points in response to the case advanced by the appellant? All of which assume against myself, I'm happy to take, that there is something to be questioned about the motive. Firstly, there is no merits test, either explicit or implicit, in Article 4. No court or commentary has ever hinted that there is. There is no doubt, there is no dispute between the parties that meritless claims should not be pursued. But the judicial tools to deal with hopeless claims against English domiciled defendants is domestic law, not EU law, specifically the strikeout and summary judgment powers and the inherent jurisdiction of the court. The relevance in such circumstances of EU law is simply to allocate which national court has jurisdiction under its own laws to summarily dismiss the case. Secondly, the motivation of a claimant is equally irrelevant to the operation of Article 4. That is a point exemplified through contrast with the very cases of abusive EU law upon which the appellant appears to rely. They concern alleged abuse of then Article 6 of the judgment regulations, now Article 8 of the recast regulations. It might be helpful, the submissions I follow, I know the court will be very familiar with the regulations, but if we could just quickly look at Article 6, which you'll find in tab Authorities 2, tab 24, MS 3473. So we're going to look at Article 8 of the recast. And we see that a person domiciled in a member state may, so you'll immediately see the move from mandatory language into discretionary, also be sued where he is one of a number of defendants in the courts for the place where any of them is domiciled, provided the claims are so closely connected that it is expedient to hear and determine them together to avoid the risk of irreconcilable judgments resulting from the separate proceedings. So one can see that what Article 8 does is provide some scope for judicial evaluation and discretion, not least a determination as to whether it is expedient to hear cases together. Now, what the ECJ has held is that where it can be proved on evidence that the claim against the anchor defendant is brought as a deceitful tactic with the sole aim of hooking a non-domiciled EU defendant into proceedings, then a national court can refuse to extend jurisdiction under Article 8. The explanation is that to do otherwise would allow litigants to manipulate one rule of EU law, Article 8, in order to improperly escape the proper application of another rule, Article 4. That's the explanation, and the underlying rationale is that to do otherwise would be contrary to the need to ensure that the exceptions to the general rule of jurisdiction contained in Article 4 are to be construed restrictively. A principle emphasised recently, albeit in a slightly different context, by my Lord Hodge in AMT Futures, which the court may wish to briefly turn up. It's at Authorities 3, tab 32, and it's paragraphs 11 and 12, which start at MS 3764. Oh, 11 to 30. Yeah. Paragraph 11, my Lord said this: the judgment regulations contain rules of jurisdiction designed to promote legal certainty by allowing prospective litigants, whether claimants or defendants, to foresee with sufficient certainty which court will have jurisdiction. The aim is to prevent parallel proceedings between courts of different member states and thereby avoid or limit irreconcilable judgments and non-recognition of judgments. The compulsory system of jurisdiction is underpinned by the principle of mutual trust between the courts of the member states. The general principle is that civil actions are to be brought against individuals and companies in the court of the place where they are domiciled. It would be contrary to the objectives of the regulation to interpret it as requiring the recognition of the jurisdiction of courts of the claimant's domicile, except where expressly so provides, as that would enable the claimant to determine the competent court by choosing his own domicile. And then just over the page, my Lord said, the derogations from the general rule, which confers jurisdiction on the courts of the defendant domicile, including Article 5.3, must be restrictively interpreted in order to achieve the aims of the judgment regulation. And that's a rationale that underlines the very few cases that in which the European Court has looked at the notion of abuse of Article 8, now Article 8. We deal with those in detail in our written case. Can I just, I hope helpfully, just give you the references to the key passages that highlight the principle that my Lord Hodge was addressing in AMT. The Advocate General in CDC, which is in Authorities 11, tab 108, in particular paragraph 84 at MS 6322, and the conclusions of the court between paragraphs 26 to 33 at MS 6334, and see also Freeport, where it's predominantly addressed by the Advocate General, at Authorities 11, tab 111, between paragraphs 63 and 68 at MS 6391.
Which case was that?
That's Freeport, my lord. Our own Court of Appeal has also recently held, albeit obiter and by a majority, that it is permissible, when considering the test of expediency under Article 8, to look at the merits of the claim against an anchor defendant. And again, we say their approach serves to illustrate the contrast with Article 4, because they adopted the same rationale, indeed based themselves upon the same rationale, as the EU abuse cases of CDC and Freeport, namely that deeming it expedient to extend jurisdiction to join hopeless cases against the domicile defendant would be contrary to the need to restrictively construe exceptions to Article 4. That's a case called Saba, and the court will find that in Authorities Volume 8 behind tab 85. And if I could show you first paragraph 64, which we'll find at MS 3002. 5302, sorry.
5302.
Yes, my lord. Court said there's no support, beginning of 64, there's no support in the decisions of the European Court considered above for any relaxation of the principle that derogations from the rule conferring jurisdiction on a defendant's domicile must be restrictively interpreted. And then over the page between starting at 67, just a few lines up from the bottom of 67, the court said this is looking at old Article 6, now Article 8. We consider that it would be wrong to invoke Article 6 by bringing a claim against an anchor defendant which raises no serious issue to be tried, because that would allow claimants to remove foreign defendants from the jurisdiction of the courts of the member state in which they are domiciled in a way deprecated by the CJEU. In our view, a claim against an anchor defendant that is hopeless or presents no serious issue to be tried should fall within the sole purpose or sole object exception identified at paragraph 32 in Reich Montage. This is particularly because taking jurisdiction is a derogation from the general rule, which confers jurisdiction on the courts of the defendant's domicile, and such derogations must be restrictively interpreted. In bringing an unsustainable claim against an anchor defendant, it can be inferred that the purpose of making the claim is to remove the co-defendant domiciled in the other member states from the jurisdiction of the courts of those states. It is important, and the CJEU is clearly concerned to ensure that Article 6.1 is not misused. In our judgment, it would be a misuse of Article 6.1 to allow hopeless claims to oust the jurisdiction of a domicile of foreign co-defendants. To allow the claim to proceed in the present appeal would undermine the principle that a defendant may only be sued before the courts of the place where he is domiciled. So we say that the case law, both European and now SABA, serve to underline the centrality of Article 4 and the concomitant need to strictly justify any departures from it. In other words, we say it undermines entirely the purpose for which the appellant seeks to rely upon that line of cases. That's my second point. My third point is this. Even if there was any weight to the allegations of abuse, then it's not an abuse of EU law that is actually being complained of. It's an abuse of domestic law. It's impossible to talk of EU law being manipulated when it's simply doing that which EU law mandates. There's no sense in which the claimants can manipulate where the defendant chooses to domicile itself. The real complaint is that by suing the domicile defendants, the claimants are improperly seeking to exploit rules under the CPR for service on a foreign defendant. But those rules are entirely domestic, of course, and not governed at all by EU law. And the EU law framework has no interest in the application of domestic law. See, for example, Article 6.1 of the recast regulations that says in terms, rules on service for those outside the EU will be dealt with under domestic law of the relevant national court. That's another reason why the arguments about abuse of EU law don't work. It's not an abuse of EU law that's being complained of. Fourthly, insofar as any of the arguments of the appellant can be divorced from assertions of abuse, then all we are really left with is a contention that the recast regulations permit a court to stay the proceedings on the basis of forum non-convenience. And we say that's a hopeless argument in light of Owusu. Our written arguments address the case law, they address the commentary, they address the recent drafting history behind the recast regulations, where there was an attempt by the United Kingdom to reintroduce a broader concept of forum non-convenience that was rejected. And we respond also to the way that the appellant seeks to distinguish the effect of Owusu. But we say, however one might grumble about Owusu, the position is that, as pithily described by Professor Briggs, that the ship has sailed. The debate has moved on. Fifthly, and finally under this head, there is no basis for seeking a reference. It's nothing more, we say, than an attempt to have further delay in this litigation. As the judge held below, the scope of Article 4 could not be clearer. The ECJ's rejection of forum in Owusu was unequivocal, and there's no basis to conclude that EU law is being abused at all, which is the factual predicate of all their draft terms of reference. The judge rejected the request between paragraphs 89 and 92. Lord Justice Simon did likewise at paragraph 37, and we invite this court to do the same. Might I turn to the question of real issue and what the test is? I hope I can be forgiven for stating the obvious, but there are two bases in which it could be said that no real issue arises between parties to litigation, either a pure legal impeachment, applying essentially strikeout principles, primarily focused on the pleadings, or an evidential impeachment under summary judgment principles, where even if a cause of action in law exists, in principle, it can in any event be said it's bound to fail. Now, the appellants don't simply argue both of those. They say in law it's failed, and on the facts it's bound. Law is no cause of action, on the facts bound to fail, but they go further. And they advance a submission that when assessing the merits of a case under the real issue head, the court here should go further than the standard methodology and describe what they call a test of enhanced vigilance, by which both the legal and factual elements of a claim are held to a greater degree of scrutiny than would otherwise be the case. Again, I hope it's helpful if I simply give some emphasis to our response by identifying 6 particular points. Firstly, the thrust of the appellant's written case and the way it's been primarily developed appears to be that an enhanced test is required because of the motive of the claimants. But as I've already sought to explain, that's irrelevant under this head, and they can't get anywhere because of the judge's factual finding in any event. All that's really left, and was given emphasis by my learned friend yesterday, is the size of the group, or the fact that this is group litigation makes a difference. But it is very difficult, we say, to see any principle that permits such a distinction to be made, such that the court should essentially adopt a new bespoke test. What is it about group litigation that would justify that step. It can't be the financial impact of facing a number of claimants, because the value of this case is going to be dwarfed by very many commercial cases. It can't be the inherent difficulties in managing group litigation. We have rules for that. It can't be any particular complexity about group litigation. So we say that it's impossible to identify a principle.
I thought that the argument really was based on the obvious point, we're dragging a foreign defendant in. Aren't there all these quotes from people like Lloyd L.J. about caution?
Of course there are, my lord. And
equals enhanced vigilance.
of course, my lord. And I'm going to deal with that, if I may, in a further point.
Fine.
By explaining how those concerns have really been met by the nuanced and layered tests provided by the Rules Committee under the CPR. And furthermore, just to put a point of caution about the adjectives we use, it was once described as the exercise of an exorbitant jurisdiction. But not only did Lord Gough not mean that in the way that was some interpreted, but also, as this court has held, we need to be careful about the adjectives that we use in a modern age. But I will deal with that point directly, if I may, my lord. The second point I was going to make is that the test for real issue is one of long standing that has been applied uniformly across a full range of cases, irrespective of the subject matter. It was described in 1949 by the House of Lords in the Brabo as requiring the court to ask whether a claim was bound to fail. That's a test endorsed by the House of Lords in Seekensar and again by the Privy Council in Altimo, and has been applied without criticism or complaint in a myriad of cases since. And the appellants have not suggested that those cases, and the very many cases, other cases, were wrongly decided. May I simply give you the reference to those three cases, if I may? The full version of the report in the Brabo is to be found in the supplemental bundle 6 at tab 47, MS 1563, and see in particular the speeches of Lord Porter, 1575-6, Lord Simmons, 1585, Lord du Parc, 1591, Lord Normand, 1594, and Lord MacDermott, 1596. Seekensar, you will find in Authorities 8, tab 87, at MS 5392. I'm so sorry, at 5385, and see in particular in the speech of Lord Gough, 5390, 5397, and 5399. And see the Privy Council in Altimo between paragraphs 81 to 6, MS 3097. My third point is that there are well understood reasons why at an interlocutory stage the test is set low. Logically, it needs to be the same test as a strikeout summary judgment, because it would be hard to reconcile a conclusion that there was no real issue against a party at the same time as concluding it should go ahead to a trial. Equally, it needs to be at a relatively low threshold, because it's one applied at the outset of a claim, and any court will want to apply a cautionary approach before depriving a party of a right to a trial. Fourthly, the summary nature of the court's task in a service-out application inherently militates against any form of enhanced vigilance test. The reality of what the appellants are seeking is the endorsement of a mini-trial at the interlocutory stage. We submit that would be both deeply inappropriate and deeply unfair. Inappropriate because it will lead to an obvious increase in time and costs of applications to serve out. Unfair because in cases such as this, where the only documents are those that the defendant itself has elected to put into the public domain, there is no possibility of a mini-trial on a level playing field. That's a point that was made in VTB by Lord Neuberger, and I wonder if we could just pull that up. You'll find it in Authorities Volume 10, behind tab 101. from paragraph 82 at 6052. Lordship said the first point is that hearings concerning the issue of appropriate forum should not involve masses of documents, long witness statements, detailed analysis of the issues, and long argument. It is self-defeating if, in order to determine whether an action should proceed to trial in this jurisdictions, the parties prepare for and conduct a hearing which approaches the putative trial itself in terms of effort, time and cost. There is also a real danger that if the hearing is an expensive and time-consuming exercise, it will be used by the richer party to wear down a poorer party, or by a party with a weak case to prevent or at least discourage a party with a strong case from enforcing its rights. Quite apart from this, it is simply disproportionate for parties to incur costs, often running to hundreds of thousands of pounds each, and to spend many days in court on such a hearing. The essentially relevant factors should, in the main, at any rate, be capable of being identified relatively simply and in many respects uncontroversially. There is little point in going into much detail. When determining such applications, the court can only form preliminary view on most of the relevant issues and cannot be anything like certain about which issues and what evidence will eventuate if the matter proceeds to trial. This concern is not new. Lord Justice Waller in Cherney and Derry Prasker said that whilst he appreciated that litigants do often feel strongly about the place where the case should be tried, disputes as the forum should not become state trials. He also lamented the mountain of material the court faced in that case, and suggested that it would have been better for both parties and better use of court time if they expended their money and their energy on fighting the merits of the claim.
Mr. Homer, you make the point that there are cases, and this may be one of them, where key issues about whether there's a real issue may depend upon documents internal to one side. Is there any reported case in which, on a jurisdiction dispute of this kind, or for the purpose of determining whether there's a real issue, the court has ordered very limited and focused disclosure?
There has been, my lord.
Yes.
If so, I'd quite like to be able to look at them.
Yes, of course.
There must be a reference to this in the Brownlee case, isn't there?
My lord, I think there is. It was a South African asbestosis case, and would you forgive me, rather than just deal with it now, that the answer is yes, there is.
Yeah.
Might I come back to it so I can be of greater assistance to the court than just simply dealing with it from memory? Yes, and as Mr. Gibson says, in the Unilever case, there may have been some disclosure. Yes. I'll come back to it if I may.
Well, I think the point arose in the Brownlee case because of the problem of the identity of the defendant in the Brownlee case. And the point was made, I believe, it may or may not be in the judgment, I certainly think it was made in the course of argument, that limited focused disclosure could have been sought in order to get at who was the proper defendant in the case.
Yes, and the witness statement that came, I think, on behalf of the Canadian company.
Eventually, prompted by certain remarks in this court, yes.
But it proved dispositive.
Yeah.
My fifth point is that the plea for a different test, or a bespoke test, in this case, is a recipe for uncertainty. No guiding principle is identified to clearly demark in what circumstances a different threshold should be applied, or indeed even precisely what that threshold is. Would it depend on the number of claimants? If so, how many? Would it depend upon the subject matter of the claim? If so, why? What's the dividing principle? Would it turn on the location of the nationality of the claimants and assessment of their motivation? Everybody likes to think their case is special, and everybody wants to do the best that they can on behalf of their clients. So if there is an enhanced test, one can be pretty sure that in most cases, the respondent to an application to serve out is going to argue that their case falls within that category. And one can readily see how the emergence of a whole new form of satellite litigation. Sixthly, and I hope this addresses in some part the point raised by my Lord Wilson, there is no real need for an enhanced test. It has no utility. That's because the test of real issue is but one of a series of cascading criteria which an applicant must satisfy in order to obtain permission to serve out. And the combination of these rules, moulded and modified over time by the Rules Committee to reflect issues that have arisen are designed, their purpose is to ensure that only cases that are properly to be joined, when a foreigner is properly to be joined, are. So as the court well knows, real issue is one. The party then needs to go and satisfy the court that it's reasonable to try that real issue as against the domiciled defendant. It then needs to go on and show that there is an issue, a real issue of law as against the foreign defendant. It then needs to go further and show that that foreign defendant is a necessary and proper party to the action. And it then needs to go further still to show that England is the appropriate forum. So the very real concerns about dragging the foreigner to the English courts are catered for and addressed by the rules. Could I turn to the common law claims? We set out our analysis of the common law claim between paragraphs 106 to 138 of our printed case, from MS 308 onwards. And I hope it's helpful if I simply again highlight some points, and I have 6 to make. First, a conceptually useful conceptual starting point is to ask whether the operator of the mine, KCM itself, is capable of owing a duty of care to the claimants not to discharge dangerous levels of toxins into the waterway. The answer we submit is obvious. The duty on a polluter in those circumstances is legally unremarkable. Indeed, it would be remarkable if no duty of care could arise. The answer to Lord Atkin's question as to who is my neighbour is given a very literal answer in the circumstances of this case. So that's starting point. Does the operator owe a duty? The second point, the second step, is that if the operator does owe a duty, then there's no reason of principle why that duty cannot also be owed by a third party if, on the facts of a particular case, that third party is the one who has control and responsibility, or shares control and responsibility, for the relevant aspect of the operation, here environmental risk management. How that control might be exercised will, of course, vary from case to case. It might be hands-on management. It might be by the setting of standards. It might be by the enforcement or monitoring of standards. But as a matter of principle, there is nothing remarkable with the idea that if they control the activity, they too can owe a duty of care to the class of claimants. And that approach, we submit, is entirely consistent with long-established principles of tort law, which recognise that, dependent upon the facts, a duty may be owed by one party to protect others from damages caused by a third party. A well-known and obviously authoritative example is Dorset Yacht. That's obviously a case this court knows very well, but it's sometimes instructive to be reminded of the simplicity of the principle. Could I just give you for your notes, see by way of example, Lord Morris. This is in Authorities 5, tab 54. See Lord Morris between MS 4394H to 4396B. Note also that in Dorset Yacht, despite the researches of counsel and the court, only one similar case to Dorset Yacht had been identified before the appellate committee, and that was a case before the Ipswich County Court. But nevertheless, the court had no difficulty in identifying as a matter of principle why a duty could be owed. This is, of course, a simple and straightforward, as the heart of all my submissions. It's a simple and straightforward notion of liability. And so we say with respect, so it should be. In order to work as a means of fairly adjudicating disputes between private parties, tort law needs to be simple and readily understandable. And the simplicity of this approach is reflected in the judgment of Lord Justice Sales, as he then was, in the Okpabi case. Dissenting, obviously, as to outcome, but not on this point as we see it on principle. If the court would turn it up in volume 1 of the authorities behind tab 14, going to start from paragraph 142 at MS 3357. And from 3 lines down, his lordship said, it is well arguable that in English law terms, SPDC, that's the operator, that's the Nigerian subsidiary, would owe a duty of care to those whose pipe property in the vicinity would be damaged by spillage of oil from the pipeline and facilities under its management. Neighbouring landowners are likely to be in a relationship of proximity with the subsidiary and cannot be said to be an indeterminate class of persons. It's also arguable that the subsidiary would be in a relationship of proximity with those claimants whose health or livelihood depend upon the use of land or water affected by the oil spills, but who would therefore also suffer loss as a result of such spills. For the purposes of analysis under English law, the same would be true of any shell company around the world operating an oil pipeline in the vicinity of property belonging to others. If the parent can be shown to have taken over practical control of the management of the operation and security of the pipeline and facilities from the subsidiary, or to have exercised joint control of the subsidiary, it's well arguable that the parent would likewise be in a relationship of proximity with the claimants, or at least a significant number of them. Thus, contrary to the views of the judge, I don't think the parent has a good answer to the case against it based on the famous dictum of Chief Justice Cardozo that the recognition of a duty of care will not be appropriate when it imposes liability in an indeterminate amount for an indeterminate time to an indeterminate class. To take by way of example, a claimant who owns land in the vicinity of the pipeline which is damaged by the oil suffering it, the claimant will be a member of a determinate class who suffers loss at a determinate time and in relation to a determinate amount by reference to the impact on the value of his land. The obvious risk of serious harm to neighbouring property owners posed by the spillage creates proximity and defines the relevant class to whom the duty is owed. It's arguable that other claimants are within the relevant classes meriting protection by recognition of a duty of care on behalf of the parent as well. Counsel for the parent emphasised that we should examine whether it had assumed responsibility for the risk of harm in relation to this group. The authorities indicate that the assumption of responsibility and the fair, just and reasonable test expounded in Comparo tend to run together. However, on the claimant's case, the parent has taken control of the management of the operation and security of the pipeline facilities, and hence the management of the risk of spills. If the claimants make out such a case at trial on the facts, I don't think there'll be any insuperable difficulty in saying the parent had assumed responsibility for the proper management of the relevant risk in a way that engages legal responsibility in relation to at least some of the claimants. The duty of care would arise in the same way that the subsidiary would in English law terms, if left control of those matters itself, have assumed responsibility for that risk in a way which would engage its responsibility. Sorry. On this view, if the factual allegations made by the claimants are made out, it's my view it would be a true Chandler and Cape type of case. If on the facts the claimants make out its case that Vedanta exercised control and direction of the operations of KCM and or imposed policies pertaining on the relevant part of the operations and or enforced them, then the appellant's contention that this case is one of pure admission entirely mischaracterises the case. On the claimant's factual case, the relationship between the parent and the subsidiary cannot be sensibly compared to the relationship between the police and the murderer in Michael, or the relationship between the trespassers and Littlewoods in Smith, let alone on our factual case, is Vedanta akin to the priest and the Levite on the other side of the road. This cannot be said. It is a case in which the defendant, on our case, played no active part. Equally, the case as presented by the claimants and its legal formulation has no bearing at all upon the principle of the corporate veil. The juridical basis of the claim against the parent is not premised on the fact of it being a parent. It's rather because of what it is alleged it did do and did not do as an independent legal personality. The relevance of that relationship is likely to be of factual significance in some cases, and this, we say, is one of them, a point put more elegantly by Lord Justice Sales in the Unilever case in paragraphs 36 to 37 that I know that the court has seen, but for your reference again, that's in Authorities 1, tab 5, MS 3074, paragraphs 36 to 7. And that is why, however much the appellants would like to portray our case as an attempt to pierce the corporate veil, or float it as a matter of some relevance in the identification of a duty, they are, as Lady Justice Arden so emphatically declared in paragraph 69 of Chandler, MS 3190, mistaken. Indeed, the logical conclusion of the arguments being pursued by the appellant are that parent companies should be afforded a greater protection in tort than any other third party. That really would be against the direction of travel. My third point is that these conventional principles have founded over 20 years of case law in which parent companies have been found to be capable, at least arguably, of owing duties to those impacted by the activities of their subsidiary. Our printed case follows the story from the approach of Mr. Justice Morris Kay in Lungowe, through Chandler to the recent cases in Shell and Unilever. And what is striking is that in every case considered by the court, the core proposition that a duty of care could at least arguably be owed has been considered wholly unremarkable. And indeed, in the two more recent decisions of the Court of Appeal, in Shell and in Unilever, the Court of Appeal has endorsed the reasoning of the Court of Appeal in this case. The appellant's contentions in their written case that all those cases, which they don't contend were wrongly decided, can essentially be distinguished on the facts, is, and I hope I can be forgiven for saying this, akin to an argument that Donoghue and Stevenson is no more than a case about Paisley's ginger beer. Three cases merit particular examination, we submit: Lungowe, Chandler, and the recent decision of the New Zealand Court of Appeal in Hardy. Lungowe, we say, is a case with strikingly similar features to this claim. It included a claim for environmental damage brought by local residents to the subsidiary's mine in South Africa, said to be harmed by its activities. The claimant group, which was large, indeed considerably larger than the claimant group here, consisted of both employees of the subsidiary but also neighbours in the surrounding area. Neither the Court of Appeal nor the House of Lords thought there was anything remotely remarkable about the duty of care that was being contended for as against the parent case. Could I just start with the House of Lords, if I may? It's in Authorities Volume 1 at tab 10 in the speech from 3219. But if I could pick up, please, in the speech of Lord Bingham at 3223. And just so you can see the nature of the facts in Lungowe, above letter H, there are at present over 3,000 plaintiffs. Each of them claims damages in one of the 11 writs issued against the defendant. All the plaintiffs claim damages for personal injuries and in some cases death, allegedly suffered as a result of exposure to asbestos, and its related products in South Africa. In some cases, the exposure is said to have occurred in the course of the plaintiff's employment, in others as a result of living in a contaminated area. And just over the page, you can see that although it was 3,000 claimants in that just before A, just at the bottom of A, you can see that instructions to sue have also been given by more than 800 additional claimants. So that was the claim. If the court would then move, please, to 3224, to the bottom, just below G, some of the claims made in these actions date back to times when the defendant was itself operating in the province, but the central thrust of the claims made by each of the plaintiffs is not against the defendant as the employer of that plaintiff or as the occupier of the factory where the plaintiff worked or as the immediate source of contamination in the area where that plaintiff lived. Rather, the claim is made against the defendant as a parent company which, knowing, so it is said, that exposure to asbestos was gravely injurious to health, failed to take proper steps to ensure that proper working practices were followed and proper safety precautions observed throughout the group. In this way, it is alleged that the defendant breached a duty of care which is owed to those working for its subsidiaries or living in the area of their operations, with the result that the plaintiffs thereby suffered personal injury and loss. Some 360 claims are made by personal representatives of deceased victims. As reformulated during the first Court of Appeal hearing, the main issue raised by the plaintiff's claim was put in this way: whether a parent company, which is proved to exercise de facto control over the operations of a foreign subsidiary, and which knows through its directors that those operations involve risks to the health of workers employed by the subsidiary and or persons in the vicinity of its factory or other business premises, owes a duty of care to those workers and or other persons in relation to the control which it exercises over and the advice which it gives to the subsidiary company. And then just, if the court would be so kind as to go to page 3231, His Lordship held just above G, by number 2, the plaintiff's claims raised a serious legal issue concerning the duty of the parent, the duty of the defendant as a parent company. So this duty didn't strike the House of Lords as being in any way unremarkable. And that was also a view taken by the Court of Appeal. The case went to the Court of Appeal on 2 occasions. Perhaps the most convenient place to identify the relevant citations is paragraph 111 of our printed case at MS 311. We set out relevant citations from the first Court of Appeal from Lord Justice Evans and the second by Lord Justice Pill. The other case of particular importance, we say domestic cases, is Chancellor, because obviously this is one of the very few examples in which the issue has been tested properly via evidence at a trial. We find Chandler at volume 1 of the authorities at tab 8, starting from MS 3173. Obviously, as with any case, it's possible for either party to pick out salient facts in Chandler and whether or not they do or don't fit with the facts of this case. We do so ourselves in our written case. But perhaps it's more instructive to try and identify some of the underlying principles. And could I start, please, at paragraph 63, because at paragraph 63, having identified that this is the first case that's going to look at directly at the issue of company liability in the realm. I'm so sorry,
MS
my lord.
number, please.
I'm so sorry.
MS number.
I'm so sorry, my lord. 3188.
Thank you.
Her ladyship, we can see from 63 onwards, does indeed apply an analysis based on analogy. So she looks really at 3 sources of cases. For general principles, she identifies at paragraph 63 Smith and Littlewoods, and she's already looked at Dorset Yacht, and comes to again at 65. So she looks for big principles there. She identifies specifically by comparison with the cases of independent contractors, and we see that at paragraph 65, cases such as Gray and Clay and Crump. And then she looks at some of the interlocutory decisions, Lungowe and Connolly, to look for, by way of analogy, to cases that have looked directly at parent company, albeit at an interlocutory stage. So the approach of her ladyship is one based purely on analogue. Paragraph 66, her ladyship identifies two things. Firstly, we see it 4 lines down. There is nothing in either in the argument, either in judgment or in general law, to support the submission made by counsel that the duty of care can only exist if the parent company has absolute control of the subsidiary. Moreover, if a parent company has responsibility towards the employees of a subsidiary, there may not be an exact correlation between the responsibility of the two companies. And then this, the parent company is not likely to accept responsibility towards its subsidiary employees in all respects, but only, for example, in relation to what might be called high-level advice and strategy. And that's how we put it in this case. There is nothing in my case, we submit, that means that if a duty is identified here in respect of environmental pollution, it must mean that the parent company will be liable when somebody falls off a ladder in their Brazilian operations. That's not the nature of the case that we've put. Paragraph 72. Her ladyship makes plain that Chandler is an omissions case. Counsel submits that it's significant there's no evidence that the parent had any responsibility for devising or implementing operational policies, and there's no complaint about any specific advice that Dr. Smither gave, and no evidence that the parent dictated the subsidiary's policy on health and safety. I do not find this to be surprising, as what is complained of is not the taking of any particular step, but the omission to take steps or give advice. So Chandler's is an omissions case. And see also at 74. Again, it's a stress about the systems. I accept counsel's submissions that Cape was not responsible for the actual implementation of health and safety measures at Cape Products. I should say, on our case, we say that the parent company was responsible, at least jointly. As the judge observed, this is at the bottom of paragraph 74, the problem was systemic. We can see the nature of the duty again at paragraph identified by the Court of Appeal at paragraph 78. Given the parent's state of knowledge and its superior knowledge about the nature and management of asbestos risks, I have no doubt that in this case it's appropriate to find that it assumed a duty of care to advise on what steps the subsidiary had to take in the light of its knowledge then available to those employees with a safe system of work, or to ensure that those steps were taken. The scope of the duty can be defined in either way. And that leads her ladyship to the conclusions that she reached, the summary that she gives at paragraph 80, which is a non-exhaustive illustrative list that dovetails with the further analysis of Lord Justice Simon, in this case at paragraph 83 of the judgment of the Court of Appeal. Could I just give you the reference? It's MS 413. It's quite wrong, we say, with respect, to suggest that in any sense the subsequent case of Thompson qualified Lady Justice Arden's analysis. To the contrary, Lord Justice Tomlinson made plain that Chandler was no more than illustrative of the circumstances in which a duty arose. Can I just show you that passage? We're in the same volume behind tab 16, It's paragraph 33 at MS 3429. At the previous page, His Lordship had just set out paragraph 80 of Lady Justice Arden's judgment in Chandler. And then His Lordship said this: it's clear that Lady Justice Arden intended this formulation to be descriptive of circumstances in which a duty might be imposed, rather than exhaustive of the circumstances in which a duty may be imposed. I respectfully adopt the formulation in Clark and Lindsall. The factors set out in 1 to 4 of Lady Justice Arden's judgment, however, do not exhaust the possibilities, and the case merely illustrates the way in which the requirements of capare may be satisfied between the parent company and the employee of the subsidiary. Thompson was a case, again, that went to trial, but it was, on any view, an ambitious case, where the only basis at trial on which it was said that the parent company had responsibility was because it appointed one member of the subsidiary's board responsible for health and safety. That was it. Things didn't get much better on appeal, where the only additional factors that were able to be identified were the fact that the livery of one van of the subsidiary had the logo of the parent. There was note paper referring generically to Renwick, and there was the possibility, no more than that the parent paid for a single taxi ride between London and Manchester. All the English cases were recently reviewed by the New Zealand Court of Appeal in a judgment handed down just before Christmas, the case of Hardy, in the supplemental volume 6, behind tab 48. I'm so sorry, that's MS 1598. I'm so sorry. The judgment was given by Her Honour Justice Winkleman in a case concerning service out of the jurisdiction in a substantive case against various entities in a group of companies alleged to have manufactured and supplied defective building products. Can I just take a canter through it, just to essentially identify the relevant paragraphs for the court? You can see the principal issue set out succinctly in paragraph 1. When may a parent company be liable for defective products made, marketed and sold by the subsidiary company? That is the principal issue on this appeal. In the context of service out on Australian companies who were part of the same group, the parent company sought to set aside service on the basis there was no arguable case against it, and we can see that at paragraph 19. Where the judgment sets out the relevant test under the High Court of New Zealand rules, which bear striking similarity to our own. The heart of the parent company's submissions are set out from paragraphs 23 and 24, which are essentially mirror those advanced by my learned friends. That this is the parent was a mere holding company that didn't exercise control over the subsidiary, and arguments that an approach that identified a duty in those circumstances would violate the principle of corporate separateness. The New Zealand court were well aware of the principle of separate legal personality. Her Ladyship, Her Honour, dealt with it at paragraphs 28 through to 33, concluding it's common ground, therefore, that something more than ownership and the ability to control which come with that is needed to justify the imposition of a duty of care in the circumstances of this case. From paragraphs 34 to 38, Her Honour sets out the approach in New Zealand law to dealing with duties of care, having identified that no case in New Zealand had dealt with this subject matter before. And in the absence of a New Zealand authority, Her Honour turns at paragraph 39 to a review of comparative jurisprudence, starting between 40 and 45 with Australian cases, in particular 2 conflicting decisions of the Australian courts. She then turns from paragraph 46 to 59 to look at the English cases, starting with Chancellor through to Unilever. Paragraph 60 to 61, Her Honour looks at Canadian cases. And then paragraph 62 to 66, Her Honour draws together principles from those cases. Could I ask the Court to be so kind as to read paragraph 62 to 66?
Of course, her category C of potential liability is cast upon the decision under present appeal.
So I'm so sorry, my lord. 65C.
Yes, footnote
That's what I meant to
83.
Yes,
refer to.
yes, yes. I'm so sorry, my lord.
Yes, very well.
Also instructive, I don't ask the Court to read it now, but between paragraphs 67 and 93, Her Honour identifies the nature of the evidential dispute that was before the Court, which again is strikingly similar here, where the Court was presented with affidavit evidence from the parent and the subsidiary saying we're totally different operations, there's no level of control over the operations, and a more limited evidence from the claimants dealing with materials in the public domain. And the Court of Appeal concluded that the case was arguable.
But it's very helpfully summarised in paragraph 92.
Yes, my lord.
Yes.
So, of course, my lord, this Court isn't bound by much, and it's certainly not bound by the Court of Appeal of New Zealand, but it is a case that very much, we say, fits comfortably with our own development of the law, both as to terms of general principles and then in terms of its application in the realm of parent company liability. And all of that comfortably and reassuringly fits within the direction of travel in other common law countries, which must always, we say, be a reassurance when assessing where we are with our own common law. My fourth point is that, flowing from that, is that this case fits comfortably into established principles of negligence identified in case law. And as this Court has recently explained in a series of cases, such as Robinson and Darnley, and also by my Lord Wilson in NRAM, if that's right, there's no need for a court on a case-by-case basis to reapply a Caparo test as to whether it would be fair, just and reasonable to impose a duty of care. But even if it were thought that somehow that test required identifying facts of great similarity in order to establish a duty, which we say is not the test. But even if it were, then at this interlocutory stage, it can hardly be said that any development of the law that is necessary would be a giant impermissible leap. If Lord Bingham thought the duty of care unremarkable in Lungowe, then it would be difficult, we say, to identify a reason why the claimants cannot satisfy an approach by analogy. Fifthly, even if, contrary to all those submissions, the court felt that it would be appropriate to consider whether it was fair, just and reasonable to impose a duty, that is not a question that can be fairly disposed of or answered in the negative, at least, at this stage of proceedings. Unlike very difficult cases such as that recently considered by this court in James Bowen, the court may remember it's the case about duty owed to police officers in respect by their employer in respect to investigations, it's very difficult, we submit, to see why it could be said to be contrary in any sense to public policy to impose a duty on a party who control operations that have caused personal injury to others in circumstances in which they were aware of that risk. The imposition of such a duty gives rise to no conflict with other duties. It's plainly not inconsistent with any principles of justice, including distributive justice. It doesn't, for example, give rise to consequences to the prospective tortfeasor that have ramifications that can't be anticipated and or insured against. And it's very difficult, we say, to see why the law should shield a party from the direct and foreseeable consequences of its own acts and omissions, a fortiori where they cause personal injury. As the intervention of civil society organisations make plain, all of that is consistent with the wider international framework. To get a sense as to what the Zambian courts might consider to be fair, just and reasonable in respect of an imposition of a duty on a parent company, we can look in the context of the Naizulu claim as to what the High Court said in their judgment. You'll find that in Appendix 2, Volume 9, tab 104, and I'm going to pick it up, if I may please, at MS 2914. Now this, of course, was a case against the subsidiary, but you'll see from the terms of his lordship's judgment that he, for his own purposes, was not distinguishing between the subsidiary and the multinational. So, actually, if I could just pick it up, if I may, on 2915. The first defendant must bear moral, criminal and civil liability for this appalling tragedy. Here is a multinational enterprise which has no regard for human life for the sake of profit and turned the residents of Chingola into guinea pigs and showed no remorse. In their countries of origin, such recklessness would have been visited by severe criminal and civil sanctions. And then over to 2917, towards the last paragraph of that page, I order KCM to pay damages, including punitive damages. This is to deter others who may discharge poisonous substances without diminishing their potency, not to cause harm to the environment, human beings, animals, etc. I reiterate that this was a lack of corporate responsibility and a criminal and tipping point for corporate recklessness. Costs will follow the event. This judgment may appear to be investor unfriendly, but that is having a dim view to KCM's don't care attitude whether human life, which is sacrosanct in our constitution, was lost or not. International investors should observe high environmental standards. That is a global approach. The fact that the host country is in dire need of foreign investment to improve the well-being of its people does not mean its people should be dehumanized.
But all that's very much a double-edged sword, isn't it, for your later submissions about substantial justice?
Well, my lord, I'm going to, no, for reasons I will explain, because as I'll seek to explain by authority, not least Lungowe, general notions of public policy are irrelevant when you consider the question of appropriate forum. So I could see how that could feed in.
Substantial justice in Zambia.
Oh, I see. Oh, I'm so sorry, my lord. Yes, well, of course, if the matter stopped there.
I know you say it doesn't, but I'm almost teasing you, but you can look at it two ways.
As I'm sure, with many of my points, my lord. Yes, but I'll deal with.
Of course,
with that,
of course you
as
will.
I may. But for the present purposes, this serves as a caution before this court would conclude that this case can be dismissed now, because it would never be fair, just, and reasonable to impose a duty of care. See the position of the Zambian courts. My sixth and final point under the common law framework is that even contrary to all my primary submissions, this is a case that could be described as in any way legally novel, then that of itself inures against summary disposal. That's the point made by Lord Collins.
This is the paradox.
Well,
Yes, I think that Lord Collins says it's a paradox, does he not?
yes.
Yeah. But you say you're entitled to found on that. It points against summary disposal if the law's not clear. Yeah.
Particularly on a point such as this. Particularly I mean, this is an important, contentious issue, potentially. It is of potential profound importance. How much better to chart out the boundaries of the law through the hallmark of fairness of the English civil system, a trial on the facts. And the Privy Council's judgment at paragraph 84 of Ultimo, MS 3097, tab 6 of volume 1.
MS, sorry, 3.
3097, my lord, paragraph 84. Stands as a salutary reminder of when courts attempted to strike out novel claims. But it sets out the importance. The general rule is it's not normally appropriate in a summary judgment procedure to decide a controversial question of law in a developing area, particularly because it is desirable that the facts should be found, so that any further development of the law should be on the basis of actual and not hypothetical facts.
I'm sorry, I must have taken down the wrong page reference.
My lady, it's 3097.
3097,
Yes.
Thank you.
Which bundle is it?
It's an authorities one, my lord, behind
Thank
tab
you.
6.
Thank you.
So the board sets out that principle. It then sets out a number of cases in which the House of Lords has given stress to that, including the citation from Exham, Bedfordshire, that where the law is not settled but is in a state of development, it is normally inappropriate to decide novel questions on hypothetical facts. But that's my backstop submission, because as I hope I set out, there is nothing remarkable at all about the legal framework of this case. Could I turn then to statute? We deal with the claim under Zambian statute between paragraphs 89 to 105 of our printed case, from MS 303 onwards. Also, if the court would be so kind as to turn up our printed case, you'll see an annex. Annex 2 at page 300, MS 373. In which we analyse the various key points in each statute, cross-refer it to the evidence. We've submitted electronically, there have been some problems with the numbering of bundles, and so we've submitted electronically an updated version. I hope that's of assistance. I can deal with this, I hope, quite quickly, because the case under statute becomes relevant if the court considers that a common law claim can only proceed if there can be analogous common law cases identified, so if there's a need for analogue, and if this court concludes, contrary to my submissions, that public policy can be a relevant consideration in the identification of the duty. So statute, which is obviously a freestanding case, but it becomes particularly relevant on a service out if you're attracted by my learned friend's submissions on the common law, because those are not tests that are required to be applied under the statute or under the 3 statutes that are pursued. As our expert makes plain, the issue under the statute is simply one of fact, whether or not the parent company did have relevant control over the relevant operations of the subsidiary.
What's the page reference to your expert report?
My lady will find, it's Mr. Mwenya, Core Volume 6, Tab 61, MS 1725. I was just going to take you very briefly to just to a few passages. I hope what's helpful, I don't think there's much purpose in trawling through all of the 3 statutes on which to rely, but could I just take one by way of an example so you can see
if you could, in principle, help us on this suggestion by your expert that fault is needed, but not a duty of care. We need to get our heads round what that really means.
Yes. Well, my lord, fault in respect of breach. So,
Breach of what?
Breach of. So, is there a
Breach of the statute.
Precisely. Was there a discharge of toxic waste, and was that discharge essentially a negligent one? You don't have to have a pre-existing duty under statute.
Negligent, did you say?
Yeah. Well, I'm using negligence in part in shorthand. Can it be criticised? I mean, if the discharge was in circumstances that would not attract criticism, then even though, as a matter of principle, the parent company can be liable under statute, it will not, in fact, be liable. But what it doesn't mean is that you have to go back to a common law analysis and say, is there a proximate relationship? Identify proximity. It certainly doesn't mean you can say you can only be liable under statute if you've been liable in some other circumstances. And there's absolutely no room for a public policy analysis within the terms of that statute.
The general theme of these statutory provisions is that they impose strict liability of what one might call a statutory Radisson-Fletcher type. And your expert says, well, yes, on the licensee, the subsidiary, but they also impose liability on third parties if he must mean the third parties, are at fault. It would be a very odd interpretation of his opinion to say, well, you first ask whether it's a sort of, whether you could say the subsidiary is itself at fault, because it doesn't matter, he's strictly liable. So it must be looking to whether the third party has done something which can properly be criticised,
Yes.
isn't it?
So
but if that's done something or omitted to do something, but if the third party can say, well, I'm not under any duty, how can its inactivity be criticised?
Well, because my lord, the expert looks at it from slightly the other end of the telescope. So the expert says, firstly, if you control the operations, but you are not an operator, can you nevertheless be liable under the terms of those acts? Answer, yes. It all depends on the facts. If you control it. So you may control it. Let's say you control it by means of mandatory policies. Let's say there is a spill, and the spill was contrary to those mandatory policies, and the operator had done everything it could do to ensure that those policies were properly implemented. But in fact, the spill was the direct cause of a maverick employee of the subsidiary, for example. In those circumstances, one can anticipate that a court would conclude that there was not liability on the parent company. But that doesn't, but there's no requirement to ask oneself a series of antecedent questions which are relevant to a common law duty, on my learned friends analysis, as to re-establishing the relevant proximity, although that's inherent, it may be thought, in the test of control, the factual inquiry into control. There's certainly no requirement to look for analogous cases, and there's certainly no requirement to ask yourself whether it would be fair, just and reasonable to impose that duty. It's simply a factual inquiry as to control and a factual inquiry as to whether the body that had control, where not governed by strict liability, was at fault looking at the particular circumstances of that discharge of pollution. But it doesn't require anything more than that. Could I just give you some references first to the three? They said that 4 acts are pleaded. The expert says 1 is not a runner, so that's not pursued. The 3 that are pursued are dealt with by our expert, who's a former Attorney General and Solicitor General of Zambia and senior counsel. He deals with the Environmental Management Act of 2011 between paragraphs 58 to 84 of his report, MS 1757, the Mines and Minerals Development Act of 2008 from paragraphs 86 to 96, MS 1768, and the Environmental Protection and Pollution Control Act of 1990 from paragraphs 97 to 107, MS 1772. If I can just look briefly at the Environmental Management Act of 2011. The relevant provisions are set out in our particular claim, which you'll find at paragraph 56, core volume 2 at tab 16, MS 647. Thanks.
You say 647?
647, yes. Section 4 is pleaded at paragraph 56. See in particular subsection 1, every person has a right to clean, safe and healthy environment. 2, includes the rights of access. 3, a person may, where the right referred to in section 1 is threatened or like to be threatened, as a result of an act or omission, bring an action against the person whose act or omission is likely to cause harm to human health or the environment. And then 4F, subsection 4F, provide, the action referred to in subsection 3 may provide compensation. We then set out some substantive paragraphs in the following paragraphs, including at paragraph 58 under section 6, some of the general principles that inform the application of the Act, including at C and D, the precautionary principle and the polluter pays principle. Over at MS 650, we set out again some further sections of provisions of section 2. See at the bottom, a polluter means a person who contributes or creates a condition of pollution. Polluter pays means the principle that the person or institution responsible for pollution or any other damage to the environment shall bear the cost of restoration and cleanup. And then section 110, paragraph 66, establishes a right, it is alleged, in respect of acts and omissions. Subsection 1, a person may sue for damages in respect of an act or omission that constitutes a contravention of this act. And to subsection 2, that right is the right in subsection 1 is in addition to any other legal rights. And we can see the compensatory principles in subsection 3. Breach is pleaded at paragraph 68. I beg your pardon, 92. At 669.
So your last point, so
Breach, we plead, my Lord, at paragraph 92 at MS 669.
Thank you.
Mr. Mwenya, our expert, deals with this act in his report. You'll find at core volume 6, tab 61. We start from paragraph 58, which is at MS 1757. Notes the way it's pleaded in the particulars of claim at 58. At 59 and 60, he sets out the particular context of the Act, which was to extend environmental protections in Zambia. And notes at paragraph 60, it's a superior Act in environmental matters subject only to the Constitution. At paragraph 67, at MS 1761, he notes that contrary to the pleaded case, the standard of liability is not strict liability. That needs to be express, he says. It's express against the, in the absence of any express provision, it's very clear a Zambian court will construe the standard of statutory liability as requiring a level of fault equivalent to negligence on the part of the defendant. So there's no strict liability either as against KCM under the statute. Paragraph 68, you get the conclusion under section 4. If claimant succeeding in establishing that Vedanta assumed some responsibility for high-level oversight of environmental policy and standards at KCM's operations, and it subsequently failed to secure that oversight, they have a real prospects of success. The expert then turns to section 110, starting at paragraph 71 on page 1763, where he says that the terms of the Act are clear and unambiguous, and then he says why that's a tool of statutory interpretation under Zambian law. And then just 6 lines up from the bottom of that paragraph, accordingly, if a parent company assumes responsibility over aspects of environmental policy or compliance by its subsidiary, and the parent company fails to ensure adequate oversight of the subsidiary's environmental practices, that is capable of constituting an omission that is likely to have an adverse effect for the purposes of section 110. The focus of section 10 is the act or omission. It doesn't stipulate who can be sued.
So does that go beyond control, which you've accepted as the test for common law liability? If you set general policies which you expect a subsidiary to perform and you don't oversee those policies, would there be statutory liability while there mightn't be in common law?
Well, can I answer that question in 2 ways? I mean, one that is certainly how a duty, we say, could arise under common law. I mean, if a company sets the policies over a particular activity in the knowledge that if those policies are not complied with, damage or result, that is certainly a way that liability can arise. It can be a form and a manifestation of control.
I wonder about that. But anyway, in any event, even if you were wrong about that, are you saying that what your expert is suggesting is that setting policies which the subsidiaries are to carry out would bear with it an obligation to enforce those policies?
Yes, on the face of the report, my lord, yes.
Yes. Thank you.
Could I just add, following from my lord's comment about the question of policies, could I just, without wanting to distract from my analysis under the statutes, could I just say this? Obviously, at this stage, we premise a case on what we assert is the factual position that the parent company does promulgate policies and does impose them. Now, what we don't know at this stage, because we have never received the policies, is whether those policies are defective, and that is the reason for the ongoing pollution, or because despite setting those policies and despite the level of control that we say the parent has over the subsidiary, they are not enforcing those policies. So it might be said, well, you were seeking to have it both ways, but that's entirely fair enough at this stage when we don't have sight of the policies. We assert that there is a level of control, in part evidenced by the promulgation of those properties. We know there is we assert there is ongoing damage. Whether or not this turns out to be a case put on the basis of defective policies or failure to enforce effective policies has to fairly await sight of the policies themselves. So, my Lord, that's to go back to the statute, if I may. Mr. Mwenya carries on dealing with section 110. I've shown you, I hope, 71 and 72 also, you'll see, where he says over the page at 1764, a failure, still on paragraph 72, a failure to exercise appropriate supervision over the dangerous activities of another person may, depending on the facts, constitute an omission which is likely to have an adverse effect. The fact that Vedanta does not itself possess mining rights is irrelevant if its acts or omissions directly resulted in breach of the act or caused an adverse effect. Then at 76, in my opinion, it therefore follows that Vedanta would be liable under section 110.1 if it caused or permitted KCM to emit pollutants in contravention of the emission licence. Although I can't comment on the veracity of the facts pleaded, a contention that Vedanta caused or permitted KCM to emit pollutants in contravention of its licence conditions is credible if it were proved, is credible if it were proved that Vedanta assumed responsibility and control over the health, safety and environmental standards. And finally, at paragraph 85, drawing it all together, Mr. Mwenya says, for the reason set out above, in my opinion, the pleaded claims under section 4 and 10 have a real prospect of success. And that's an analysis that is consistent with his explanation of the scope and effect of the other two statutory causes of action. Now, of course, some of those conclusions were disputed by the appellant's expert, Judge Sakala, but as the appellant rightly accepts, the court below were not in a position, on written evidence of foreign law, to say that our position was in any sense unarguable. All they are left with, we say, and it's a sign of, well, all they are left with is a pleading point. They contend that the fact that the pleading refers to strict liability, whereas the fact that our expert says fault is required, is fatal and cannot be remedied. The problem with that argument is it's based on case law that's been expressly disproved by this court. It overlooks NML Capital, not least Lord Phillips' reminder that procedural rules should be the servant, not the master, of the rule of law. For your reference, paragraph 74 of the judgment, which you'll find in Authority 6, tab 74, MS 4926, and which we analyse at paragraph 105 of our printed case. My lady, my lords, that's what I was intending to say.
Paragraph?
Of the judgment, my lord, or of our printed case?
Your written case.
Of our written case, it's paragraph 105 at page 307.
Which paragraph is it of the judgment?
It's paragraph 74.
74?
Yes.
Thank you.
If we're moving on from real issue, where is the most convenient place for us to find the actual material about the committee, the subcommittee, the framework, the shareholders' agreement, etc.? where do we go for those references?
Well, my lord, my next heading is the evidence.
Oh, I see.
And with
Good.
With
That's
the permission of the court, I was going to show you some of it and give you sources for the rest.
Thank you.
We deal with some of the evidence between paragraphs 129 and 155 of our printed case. But there were 19 volumes of it for Mr. Justice Coulson. The Court of Appeal only had a selection, and the selection before this court is narrower still. Although narrow is entirely subjective in this context. May I again be forgiven for starting a section with the statement of the obvious, which is that the evidential test, when one's looking now at the evidence and whether it came as bound to fail, requires the court to exercise real caution. And there are classes of cases, and we say this is plainly one, that will be almost by definition unsuitable for summary determination, because there is such extensive dispute on facts and interpretation of documents that it cannot be fairly determined at a summary stage. We set out authorities that will be very familiar to this court on the caution to be exercised between paragraphs 74 and 83 of our printed case at page MS 298. I hope I can be forgiven for taking the court to one authority, although it will be extremely well known, but it helps frame the submissions that follow, and it's Lord Hope in Three Rivers, which unfortunately has been duplicated in its entirety in the authorities bundle, for which is very unfortunate. If it's our fault, we apologise. It's Authorities Volume 9, tab 96. And I was going to start at paragraph 94 in the speech of Lord Hope, which is at MS 5881.
Right, 5881.
Yes, my lord.
Thank you.
His Lordship said, for the reasons I've just given, I think the question whether the claim has no real prospect of succeeding at trial and that it has to be answered having regard to the overriding objective of dealing with the case justly, but the point which is of crucial importance lies in the answer to the further question that then needs to be asked, which is, what is to be the scope of that inquiry? I would approach that further question in this way. The method by which issues of fact are tried in our courts is well settled. After the normal process of discovery and interrogatories have been completed, the parties are allowed to lead their evidence so that the trial judge can determine where the truth lies in light of that evidence. To that rule, there are some well-recognised exceptions. For example, it may be clear as a matter of law at the outset that even a party were to succeed in proving all the facts that he offers to prove, he will not be entitled to the remedy that he seeks. In that event, a trial of the facts would be a waste of time and money, and it is proper that the action should be taken out of court as soon as possible. In other cases, it may be possible to say with confidence before trial that the factual basis for the claim is fanciful because it is entirely without substance. It may be clear beyond question that the statement of facts is contradicted by, and again, all the documents or other material on which it is based. The simpler the case, the easier it is likely to be to take that view and resort to what is properly called summary judgment. But more complex cases are unlikely to be capable of being resolved in that way without conducting a mini-trial on the documents without discovery and without oral evidence. As Lord Wolfe said in Swain and Hillman, that is not the object of the rule. It's designed to deal with cases that are not fit for trial at all. And then just the citation then from Wenlock and Maloney, from the judgment of Lord Justice Danckwerts, instead of the inherent power of the court to strike out, the summary jurisdiction of the court was never intended to be exercised by a minute and protracted examination of the documents and facts of the case in order to see whether the plaintiff really has a cause of action. To do that is to usurp the position of the trial judge and to produce a trial of the case in chambers on affidavits only, without discovery and without oral evidence tested by cross-examination in the ordinary way. This seems to me to be an abuse of the inherent power of the court and not a proper exercise of that power. Lord Justice Sellers said that he had no doubt the procedure adopted in that case had been wrong, and the plaintiff's case couldn't be stifled at that stage. So that's the framework. Could I start before looking at the evidence and trying to identify conceptually how it fits together in this case? Could I first address what we submit as a particularly bold submission advanced by the appellants, that in assessing whether or not a claim is bound to fail, a court can only examine that case's merits by reference to the documentation that is already before the court, and account should not be taken of the potential impact of future disclosure, either as a matter of principle or because it can be safely concluded in this case, the claimant's case is as good as it's ever going to get. And the appellants submit that Lord Justice Simon, in this case at paragraph 85, was mistaken when he said that common experience is that disclosure can take a party further than their initial pleading. In our respectful submission, that stance is divorced not only from common experience, but more importantly, basic notions of fairness. And it is particularly inappropriate in a case such as this, in which the majority of the materials demonstrating the relevant relationship between the two companies within the same group is only likely to become available upon disclosure. The self-evident centrality of as yet undisclosed documentation to the resolution of the liability of a parent company was a point identified by Lord Bingham in Lungowe. We just quickly go to one passage, which is in volume 1, tab 10. And if the court would be so kind as to go to MS 3229. 229.
229, thank you.
And just below letter F, under the heading present cases, the issue in the present case falls into two segments. The first segment concerns the responsibility of the defendant as a parent company for ensuring the observance of proper standards of health and safety by its overseas subsidiaries. Resolution of this issue will be likely to involve an inquiry into what part the defendant played in controlling the operations of the group, what its directors and employees knew or ought to have known, what action was taken and not taken, whether the defendant owed a duty of care to employees of group companies overseas, and whether, if so, that duty was broken. Much of the evidence material to this inquiry would, in the ordinary way, be documentary, and much it would be found in the offices of the parent company, including minutes of meetings, reports by directors and employees on visits overseas and correspondence. As Mrs. Justice Aspin, as she then was, noted in a case concerning the relation in a competition in the realm of competition law and the relationship between companies within the same group. It's referred to at paragraph 80 of our printed case. The need to envisage the impact of future disclosure cannot be described as mere Macawberism. It's what we all know as lawyers happens in cases, and it reflects basic notions of fairness. And it is obvious here that there will be a raft of documentation that is either capable of proving our case is well made, or may, at trial, disprove it. They will be in all shapes and forms. It will include board minutes of both companies. It will, as a starting point, concern access to the policies themselves. It will require looking at what the framework was, which we, as to enforcement, if indeed there was a framework for enforcement. It will mean looking at and when we see the particular structure of this company, at what was before not only the sustainability, but the subcommittee on sustainability. It will involve looking at what the responses were when the parent company was told about specific spills, if indeed it was told about specific spills, which, according to its own documentation, it should have been. So there is likely to be a whole raft on disclosure of both documents we know about or known unknowns, categories of documents, the contents of which we don't know, but may well be highly relevant. And we can see the import of disclosure played out in real time if we look at the case of Chancellor, if we can go back to that. Because in Chancellor, the determination of parent company was based in very large measure upon documents that were only received on disclosure. So we're back in Authorities Bundle 1 at tab 8. It starts at MS 13173, but if the court would please turn to paragraph 5 to begin with, at page 3176. You can see from paragraph 5 that the evidence at trial was sparse and consisted mainly of documentary evidence. Only one witness gave oral evidence.
This is partly because it was all a very long time ago.
Yes.
I mean, it was something like 50 years after he was infected that he contracted the disease.
That's right.
So it's a bit of a one-off case so far as the need to rely on documentary evidence. It was a 189-year-old witness.
Yes, but, my Lord, I take that point, of course, but when one looks at the analysis...
I mean, I say that not to undermine your basic
No.
submission. I mean, it strikes me as blindingly obvious that if everything turns on the degree of control between a parent and a subsidiary, it's the internal documents of both companies that are going to matter for the purpose of finding out the truth.
Yes. Unsurprisingly, my Lord, we entirely agree. And one of the difficulties in this case generally, and I don't mean this with any disrespect to the other side, is that a lot of my submissions we suspect do amount to the statements of the obvious, and there's a sense which was slightly reticent to raise them before the Supreme Court. But it is a point I have to face, which is said that don't worry about, you don't take into account future disclosure, which we say is it's just ridiculous in a case about the relationship between two companies in which all we have at the moment is that which they have elected to place in the public domain.
Trouble is, we've got a job to do. We've got to decide real issue at this stage for the purpose of service out.
Of course, my Lord, but not by conducting a mini-trial.
No, quite.
And nor for the reasons that I have given, by adopting any approach other than the standard approach that should be applied on summary judgment. I'm not going to hide for one moment from the documentation upon which we rely. We want to invite the court to engage with it, albeit you're only going to engage with because of the nature of this appeal, with a small section of it. So I'm not hiding from that for a moment. But what I am seeking to say is that when one steps back and asks, is this claim bound to fail? It is entirely artificial to say, I need to come here and prove my case, essentially, on the documents that we currently have. That's the tip of the iceberg. And that's why, it goes back to the point I was making and why I took you to Three Rivers, because these procedures, if operated, summary procedures can be very effective, proportionate disposal of cases, but if used inappropriately, can be deeply unfair. And a case such as this, and I'll show you, there are real disputes. It's completely inappropriate to apply it here. So, if I can just do Chandler with a light touch, if I may, just to give you the paragraph numbers where you can see the centrality of disclosure. So this is a case which, on my learned friends analysis, because there was no documentation, should have been struck out at an interlocutory stage before you had these documents. But in fact, when you look at paragraphs such as, can I just give you for your note, paragraphs 14, 23, 28, 73, succeeded because of those documents. Can I be clear, maybe just to meet off any wider concerns that the court may have as to where this might take us in other cases? There's nothing in my submissions that means that in every case in which there's a bare assertion that a parent company controls the subsidiary, the court is inevitably going to green light it. There will be categories of cases in which it can be readily established that the parent company it has no operational relationship with the subsidiary. And Brownlee is a very good example by analogy. The uncontrovertible evidence eventually before this court was that the Canadian holding company didn't own, let alone operate, anything in the Egyptian hotel, let alone have anything to do with organised excursions. For your note, see paragraphs 13 to 15 of the judgments of this court, volume 4, tab 50, MS 4257. But the court may well have reached a different conclusion if, in fact, the holding company's annual report had talked in terms about the services it had offered, including the provision of chauffeur-driven excursions from the Egyptian hotel. A good example as to why it can be, in the right case, readily ascertained as to whether or not a defendant has control or not is this case, because the claim form was initially named Vedanta Resource Holdings Limited, which is the 100% holder of all the shares in KCM. But it soon became apparent that it was no more than a passive holding company, and the case against it wasn't pursued. So there is nothing in my submissions that means that simply because you put on a pleading the parent company controls, you automatically have an entitlement to go through to trial. Our case is very different to a Brownlee type of case. In order to satisfy the court that this was not a case bound to fail, even if the legal framework was sound, materials were placed before the court of first instance primarily through two vehicles. The first, the pleadings, which, although not required to, do in fact set out extensive evidence. And secondly, through the witness statement of the claimant's solicitor, that's Mr. Day's fifth witness statement. Can I give you the reference, please? It's Core Volume 5, Tab 47. He deals with the evidence between paragraphs 21 and 75 at MS 1473. Now, the majority, but not all, of that evidence consists of the appellant's own published materials that they have chosen to place in the public domain. And can I say something about the status of that and, importantly, the purpose for which we rely on it? I do not say that the publications of themselves will necessarily prove my case at trial, nor do I have to say anything close to that at this stage of the proceedings. This is obviously not a misrepresentation case in which I need to show that the claimants had any knowledge, let alone reliance on it. What we rely on those documents for primarily is to show that they are capable of reflecting the actuality. So they are capable of reflecting the actuality of control and supervision contended for, and concomitantly, they are capable of calling into doubt some of the evidence served by Vedanta and KCM that the former has no operational relationship with the latter. Of course, our case went beyond mere corporate documentation. There was also placed before the court at first instance a very limited amount of internal documentation that was exhibited to the appellant's evidence, on which we placed some reliance, not least the management agreement and the shareholders' agreement. There was also evidence from Mr. Gibson describes a middle manager giving his evidence, which again is not relied on per se because I say, see paragraphs X and Y, I'm going to succeed at trial. but see the statement as capable of reflecting the actuality, both as to the level of control, but also reflecting what, as one might expect, as a case develops beyond a preliminary stage, the additional type of evidence of that nature that may come forward. And we also put before the court below a judgment of the Irish High Court dealing with another a subsidiary, not because it's said to have any legal effect, but because the facts as emerged in that judgment are again capable of reflecting the actuality of control and direction that we contend for here. Could I do two more things, if I may, under the evidential heading of my roadmap? Could I, at this stage, start to show the court some of the materials? And then, having done so, and again, time simply does not allow to take you to the full breadth of materials, but having done so, could I then seek to draw together the nature of the evidential dispute that faced the first instance judge, and to identify the approach, we say the correct approach that he took to it. As I say, there are two sources primarily two vehicles of evidence that were before Mr. Justice Coulson, the pleadings and the witness statement of the claimant's solicitor. Could I start, please, just to identify in broadest terms how it's put out in the pleadings? I know the court has seen them before. We find that in Core Bundle 2 behind tab 16. If the court would turn to MS 654. As you've been shown by Mr. Gibson, we set out the duty contended for, firstly at paragraph 79, that puts it in broad terms, and then with the caveat that it's further or alternatively, essentially we try and identify the case as falling within the Chandler and indicia. But as we make plain in writing, the case doesn't stand or fall in our sense on the claimant indicia. The ultimate question is whether there was sufficient control and direction and how that was manifested. But it may be thought, and we hoped it is helpful to approach it in this way. We set out, having set out the nature of our case, although not, as I say, not compelled to do so, we then do set out evidence supporting the proposition of control. We set out from the top of 83 evidence in support of the duty contended for at paragraph 79, the general duty, and we do that by reference to the defendant's own publications over 5 pages, through to paragraph 84, that then over another 7 pages sets out evidence to support the contentions pleaded at paragraph 80. And although not now, we would certainly ask the court to read those materials. Could I just, I'm going to take you to a few documents, but could I just take you to just highlight a few points now, just by way of highlight to make some of my points. Could I ask you just to look at a few passages? If we start, please, first at 83H, which is at 658, page 658. Which says the defendant's annual report states that the parent's company management system, organisational structures, process standards, code of conduct together form the system of internal control that govern how we conduct the group's business and manage the associated risks. The report added, the board of directors has the ultimate responsibility for management of risks. We strive for 0 environmental incidents. We have a robust internal process for managing incidents that does occur. Health and safety is a high priority. Compliance with international and local regulations and standards, protecting our people, communities and the environment for harm. and our operations from business organisations are our key focus. The Vedanta board level committee is chaired and includes the CEO. A structured sustainability assurance programme has been launched in the business divisions covering environment, health, safety, community relations. I'm going to pick just a few because I am going to show you some of the documents, but not these. 83L at page 660. The second defendant has publicly stated that the first defendant exercises a high degree of control over its environmental control and sustainability standards. For example, a document on the second defendant website states Vedanta has also ensured that KCM complies with international best practices and operates according to Vedanta's sustainability programme. Opposite page 84C. The first defendant has assumed responsibility for modernising the second defendant's mining infrastructure and has invested very significant sums of capital expenditure in order to ensure the second defendant's operations comply with applicable environmental standards. For example, the second defendant's website states that once the first defendant acquired the second defendant, we immediately designed a comprehensive and well-funded programme to address environmental legacy issues. We particularly focused on the areas that most affected the surrounding communities when modernising infrastructure to local and global industrial norms. 85B. A corporate presentation published by the first defendant in September 14 contained a document, case study transforming water footprints at copper Zambia. That included a graph which showed the wastewater discharged from the copper mine contained levels in excess of the statutory limit every year between 07 and 11. The graph was accompanied by photographs that showed significant volumes of highly polluted water being discharged into the local environment. The same document also included a diagram showing how the second defendant's operations fell under the Vedanta sustainability framework, included the application to the second defendant of their management.
I think I've been
systems.
looking at the wrong D, Mr. Hammer.
It's B.
I'm sorry, it's B at 662.
It was B, was it?
It was B, my lord.
B, sorry. There are two Bs, aren't there?
I'm so sorry, that's my fault.
Which B is it?
It's the corporate presentation by the first defendant.
Very well. Thank you. Lastly, in the pleadings, just by way of example, page 667 at the top, this is paragraph 86E. Material published by the second defendant demonstrates the first defendant has taken responsibility for funding, designing and installing a process for the purpose of improving the copper mine's compliance with environmental standards, including the purchase of new industrial equipment. For example, a document published on their website states that most of the infrastructure that Vedanta acquired when it purchased KCM was old and in need of modernising or replacement. As a consequence, Vedanta inherited several legacies, including, and they're set out, once Vedanta acquired KCM, we immediately designed a comprehensive and well-funded programme to address the legacy environmental issues. We particularly focused on the area that most affected the surrounding communities when modernising infrastructure to local and global norms. And then there's some details set out from their own website of the finance that they provided for that.
The we there would be referring to KCM, would it?
No, Vedanta. It's a document, well...
This is the second defendant's material.
Oh, I'm so sorry. Well, I'm going to show you some documentation in a moment. That could certainly, my lord, I accept that could be read that way. I'm going to show you some document, though, in terms of when it looks at what Vedanta said they did. It could also be read as Vedanta.
I mean, this raises the big question. When we look at all this material, are Vedanta assuming a responsibility towards the villagers, or are they helping KCM discharge properly its own duty of care?
Well, my lord, I can well see a defence that says, if the documentation goes no further than this, this is it, that says, well, hang on, all we're doing, we're trying to be the good guys here. That is one way, certainly, that one could look at it. But that's not how we put it. I mean, we put it at least in two ways. I mean, one is, on its face, it's showing a level of control. that is sufficient to establish a duty of care. But for the purposes of essentially a summary judgment application, that's not really the test, we say. The test is whether these reflect a case that is properly arguable, because we say this reflects the actuality, or you can look at these documents and say our case is bound to fail. But this could only ever be read as a company that's just trying to nudge its subsidiary in the right direction or trying to get it to do the right thing. Rather, on our case, these can be read as reflecting the actuality of control and direction for which we contend for. Also, this needs to be taken, we say, these are all often documents in which a company is proclaiming its good corporate governance. And one can't always assume bona fides in that, not least in the circumstances of this case where all these documents are being published, whilst on our case, we allege, the mine is churning out toxic waste thousands of times over the levels that it's supposed to, whilst Vedanta undoubtedly we would say no about it. So of course one can, at this stage, look at documents, either party can look at documents and say, well, that supports my case, or it supports the existence only of a very narrow duty. We, on the other hand, can say, no, all we're doing is saying it reflects the arguability of our case. What you can't do, we say, is that which my learned friends contend, and look at these documents and say, the case is bound to fail. Your case on control and direction is bound to fail. Nothing else you're going to get is going to get better than this, and you have to take these at their face value. I'm sorry, that's a slightly waffling answer to my Lord's very precise question.
Thank you.
Can I just ask whether we've got the actual extract from the website from which this is an extract?
My Lord, I don't think we have that one. I'm going to show you one to similar effect, I hope. Yes, I think all of these were in the bundle below at first instance. Oh, my learned friend put it in. Well, there we go.
So it's somewhere.
It's somewhere. Could I show you the document that, as my learned friend says, is repeatedly referred to in the particulars of claim, and he says they need to be taken in their correct context. So let me show you the context. Let me take you to the document. It's a sustainability report called Embedding Sustainability, which you'll find in Appendix Part 2, Volume 7.
Page?
MS 1958, my lord. Oh, I'm sorry, I'm using the internal numbering. I'm so sorry. MS 2377. I'm going to highlight a few sections of this, if I may. Starting just over the page on the introduction at 2378. Under introduction, it talks about its vision to be a world-class diversified resource company, but could I ask you to just look at the final paragraph in that left-hand column? All Vedanta Group subsidiary companies have been reported as though they were 100% wholly owned, as we recognise the level of control and sphere of influence the group has over these operations. Now, of course, to anticipate, following on from my Lord Wilson's questions, that could be looked at and said, well, that's just a responsible way to look at it. What's to be lost from it's more responsibility. But that's not the purpose on which we rely on it at this stage of proceedings. It's to reflect our case. How can we be said to be bound to fail on a case about their level of control when they are stating in public that's what they do? Can I take you to some more passages, please? If we turn to page 2386, we get a statement from Mr. Agarwal, who is the chairman of PLC. Yeah, sorry, beg your pardon, Vedanta.
I'm just sorry, which page are you on?
2386, my lord.
Thank you.
It's in the same document.
I'm going to take you to several references in this document. It said we're taking this out of context, and so it's important to show the context. Under the heading Embedding Sustainability, the chairman says, as we grow our business, it's important that we have consistent and systematic approach to running our operations. Last year, we introduced our Vedanta Sustainability Framework. This year, we've focused on embedding and implementing it. This has meant working to train and develop our employees and contractors to roll out the framework supporting process and standards. The report illustrates these efforts, achievements. And then this, we understand our commitment to corporate sustainability requires constant monitoring and diligence, and our framework also gives us the tools to achieve this. Next column, I've consulted closely with our CEOs to ensure that the implementation is a core aspect of the business. Supported by business CEOs and the corporate team, the Sustainability Committee has worked relentlessly to drive our sustainability agenda. We can see under point 1, embed sustainable development at every aspect of what we do. You can see that the training program that's been put in place. Over the page, opposite page, under 4. Oh yes, sorry, I should point out under 1, just to carry on, the Vedanta Sustainability Assurance Programme, which measures the effectiveness of our sustainability framework, and then this, at the operational level. Under 4, we maintained our focus on how we manage our impact, our air, water and land use, and this resulted in a decline in water usage. We've achieved success in meeting many of our goals. We're now escalating benchmarks. We turn then to over the page, to 2388, to a statement from the Chief Executive Officer of the parent company, Mr. Mehta. Who talks about, in his first paragraph, about the responsibility towards the planet, the importance of that to Vedanta, and how they possibly want to seek to positively impact the world by managing their business operations sustainably. And then this, Vedanta uses state-of-the-art technology, and we're committed to embracing and developing new technologies and innovations that add economic value, create efficiency, and also make a contribution to reducing the environmental footprint of our business. For example, a few years ago, when we replaced our old copper smelter at our KCM business with the latest technology smelter, this has helped improving our metal recovery rate, which in turn has reduced our finite resource consumption. Next column, implementing our sustainability framework. Over the past year, we've embedded our sustainability framework and implementing practices and standards. We're committed to ensuring the framework is followed and managed in all our operations and new projects in order to continue our sustainability journey. Our team, comprising 600 staff in health, safety, environmental management and community engagement, is committed to support our vision.
By whom are those key staff employed? Do we find out?
We don't find out. It may be that many of them are employed by either companies that have no legal, organisations that have no legal personality. It may also be that many of those may be within the operating companies themselves. Well, I'm told it's Vedanta India. I'm going to show you a range of documentation, and I'm going to point to you how it's dealt with by Mr. Gibson's own clients in their evidence. Again, all I'm seeking to do now, this may be evidence that shows this is an extraordinarily responsible company. It may be, but that's not the purpose of which I'm relying on this. I'm trying to that my case that they control and direct the operations is not bound to fail. So we're not looking at this at the moment to say this is good, this is bad. We're looking at this in my submission to see, does this show that my case on direction and control is bound to fail?
There's another way you could put it, is that if this is the visible tip of the iceberg, it's a fair inference that the 90% of material probative or disprobative of your case, which isn't yet available, may be broadly to the same effect.
Precisely, my lord, precisely. That's why I put it in, is this capable of reflecting the actuality is the question. Now that actuality we may be wrong, but we may very well be right.
It may all be puff. But at this stage, you say one doesn't have to assume that.
That's precisely, my lord, how we put it. Yes. Because this is such an important document, I hope I can be forgiven. There are some other passages that are worth drawing the court's attention to. On the facing page 2389, we can see at the top, post-introduction of the framework, we've launched the Vedanta Sustainability Assurance Programme to measure its implementation and effectiveness across our operations, embedding the framework as a long-term project. And each site has a well-defined action plan, so they have their own, as in Chandler, both direction and targets for improvement. These plans are supplemented by appropriate guidance documents and training to ensure that the business units are supported appropriately in its effective execution. Then skip a paragraph, although I don't think in any sense unfairly, if we go to environmental incidents continue to be classified according to our internal rating system based on their severity. Incident monitoring, reporting, investigation, remediation, and preventative action is practiced with the aim of improving our overall performance. Could we then turn, please, to 2392? In the second column, under the heading Our Strategy, second paragraph, since introducing our sustainability model, we've acted to implement them across the business. Each group company has conducted a gap analysis and subsequently put in place action plans. Progress towards target is measured and monitored by teams in the businesses, but we have also developed a corporate central sustainability assurance programme supported by our external sustainability auditors. Facing page, Vedanta has a clear structure for managing and implementing the framework from the group to the operational business units. Sustainability is driven through all levels, from board endorsement at committee level, and then this through operational review and target setting by our executive committee subcommittee on sustainability, chaired by the CEO, to regular training and instruction conducted on site. One paragraph down, we've introduced clear lines of responsibility and management to ensure that business's performance is vigorously reviewed on a continuous basis with mechanisms in place to promote shared learning across the group's subsidiaries, facilitating performance. Every effort is being made to tighten the way that sustainable business practices are managed across the group. Group sustainability policies and guidance documentation are made available to all Vedanta employees through the corporate website. Over the page, we learn something about the relevant committees. We see first the Sustainability Committee, which is a fairly high-level committee, and we can see from the second paragraph, first column, some of its mandates, or its mandates rather. We can then also see that there is a subcommittee, and of which it is said, this is said, the group CEO, Mr. Mehta, chairs the committee. Then this line, the committee works at the operational level to embed and deliver the sustainable vision of the business. And then next column, the committee also reviews progress on actions to reduce accidents and injuries, on improving environmental performance and health and safety. We see then a statement on the following page from the Senior Independent Director of the Sustainability Committee. And just so we can get a sense of the standards, if we just see right at the bottom of that page, we can see, as well as about his work, as well as overseeing processes and delivery of technical standards, the Sustainability Committee is driving business on its overall approach to sustainability issues. So it's providing technical standards. We could then move forward to page 2402. Just to get another sense of the operational focus of the subcommittee. I should say that the subcommittee has no legal personality, and it is more than reasonable to assume that the body that must be responsible for it is that to which it reports, and that's whose mandate it works to, namely the parent company. Under management, we have in place a set of management structures and processes to ensure our subsidiaries and operations embrace and follow sustainable business practices. This starts with our board, which is ultimately responsible. The board has mandated Sustainability Committee to institutionalise the sustainability at all levels of the business, which in turn is supported, and then this, by the operationally focused Executive Subcommittee. On the next column, same page, we can see that the group's, one up from the last paragraph, the group's risk management framework plays a key role in the identification, analysis, mitigation and continuing monitoring of the various risks that could impact the delivery of the strategic objectives. Page 2406. You can see at the top, in the orange box, that the framework includes a suite of technical and management standards and a number of supporting guidance documents. And we can see from the first paragraph that's been reinforced by training. We've been delivering training across the group, including training on specific topics, such as health and safety, management, environmental incidents. Next paragraph repeats the point you've already seen about technology. Last paragraph of the first column again talks about the system they put in place for robust evaluation and assurance system. (2409) is under a section under health and safety, responding to the challenges of our industry. And in the orange box, it sets out under the heading group level what's being done at a group level. So processes to engage management to deepen understanding, monthly safety meetings, safety alerts, guidance notes, a programme on unsafe conditions elimination. (2417), please, which is under the heading committed to minimising our footprint. We are committed to ensuring we comply with international best practice.
Where are you now?
I'm so sorry, 2417, my lord,
Sorry.
under the heading committed to minimising our
Yeah, I missed it.
footprint.
Yeah.
I'm so absorbed in what you're saying, Mr. Hermer, and reading the document, that I've failed to notice the time, which is a cardinal sin in this place. You're well past 1:05, but we'll look forward to hearing from you further at 2:00. We'll now adjourn.